Canon 6, Accountability, Part 2, Section 21 to 35 of the Code of Professional Responsibility and Accountability. Section 21, Preliminary Conference Order, Position Papers. Within 10 calendar days from receipt of the preliminary conference briefs, the investigating commissioner shall issue a preliminary conference order on the basis of such briefs submitted by the parties and counsels, summarizing the stipulated facts, issues, and marked exhibits. The investigating commissioner shall further direct the parties to submit their verified position papers within a non-extendable period of 10 calendar days from receipt of the preliminary conference order. Section 22, Clarificatory Hearing. Within 10 calendar days from receipt of the last position paper, the investigating commissioner shall determine whether there is a need to conduct a hearing to clarify factual issues and confront witnesses. If deemed necessary, the investigating commissioner shall set the hearing within 15 calendar days from such determination and identify the factual issues to be made subject of the hearing. The investigating commissioner may subpoena any witness to appear at the hearing to answer clarificatory questions. Thereafter, the investigating commissioner may allow the parties to confront the witnesses and propound their own clarificatory questions on the factual issues identified by the investigating commissioner. The clarificatory hearing may be done in person or through video conferencing. If it is conducted in person, the clarificatory hearing shall be done at the most convenient venue for the parties. The clarificatory hearing shall be terminated within 30 calendar days from its commencement. Section 23, Minutes of Proceedings. The proceedings before the IBP shall be recorded. Section 24, Non-Appearance of Parties. Non-appearance at the clarificatory hearing shall be deemed a waiver of the right to participate therein. Section 25, Issuance of Report and Recommendation by the Investigating Commissioner. If there is no clarificatory hearing, the Investigating Commissioner shall render a report and recommendation and submit the same to the IBP Board of Governors within a non-extendable period of 60 calendar days from receipt of the last position paper or lapse of the period given. In case the investigating commissioner sets a clarificatory hearing, the report and recommendation shall be rendered and submitted to the IBP Board of Governors within a non-extendable period of 30 calendar days from the termination of the hearing. The report and recommendation shall be accompanied by the duly certified transcript of stenographic notes, or in lieu thereof, the audio recording, if any, or the investigating commissioner's personal notes duly signed, which should be attached to the records, together with the evidence presented during the investigation. The submission of the report need not await the transcription of the stenographic notes, it being sufficient that the report reproduced substantially from the investigating commissioner's personal notes any relevant and pertinent testimonies. If the hearing is conducted through video conferencing, the proceedings shall be recorded by the investigating commissioner. It shall form part of the records of the case, appending thereto relevant electronic documents taken up or issued during the hearing. Section 26, Submission of Resolution by the Board of Governors. The IBP Board of Governors shall have a non-extendable period of 90 calendar days from receipt of the report and recommendation of the investigating commissioner within which to submit to the Supreme Court its resolution adopting, modifying, or disapproving such report and recommendation. Section 27, Depositions. Depositions may be taken in accordance with the rules of civil procedure as amended with leave of the investigating commissioner. Section 28, Filing and Service. The filing and the service of papers or notices required by this canon shall be made with the commission or upon the parties personally by registered mail, accredited courier, electronic mail, or other electronic means, or as provided for in international conventions to which the Philippines is a party. For this purpose, the office address and the electronic mail address supplied by the lawyer to the IBP shall be the official addresses to which all notices, orders, and processes shall be served. Proof of filing and service shall be submitted in accordance with the rules of civil procedure as amended. Section 29, Substantial Defects, Motion to Reopen. Any substantial defect in the complaint, notice, answer, or in the proceeding or the investigating commissioner's report, which may result in the miscarriage of justice, may be raised as an error before the Supreme Court, unless the defect results in the deprivation of the right to due process. In case of the latter, the matter may be brought before the IBP Board of Governors by way of a motion to reopen within 60 calendar days from knowledge. Section 30, Proceedings initiated before the Supreme Court. In proceedings initiated by the Supreme Court or proceeding commenced by complaint filed with the Supreme Court, the Supreme Court may refer the case for investigation, report, and recommendation to the Office of the Bar Confidant or the IBP or other fact-finding body that is designated or created by the Supreme Court for such purpose. Cases referred to the Office of the Bar Confidant or other fact-finding body or the IBP shall proceed in the same manner provided in sections 5 to 29 of this canon. In any event, the report and recommendation on the investigation shall be reviewed directly by the Supreme Court, which shall take such necessary action on the report and recommendation as may be warranted. Section 31, Preventive Suspension. After receipt of respondent's answer or lapse of the period, therefore, the Supreme Court, on its own initiative or upon the recommendation of the IBP Board of Governors, the Office of the Bar Confidant, or the fact-finding body referred to in Section 30, may suspend a lawyer from the practice of law during the pendency of the investigation for a period not exceeding 180 calendar days, or until such suspension is lifted by the Supreme Court, in order to prevent interference with or obstruction of the investigation, tampering, concealment, or destruction of evidence, intimidating or exerting undue influence on any witness. Section 32, Quantum and Burden of Proof. In administrative disciplinary cases, the complainant has the burden of proof to establish with substantial evidence the allegations against the respondent. Substantial evidence is that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Section 33, Serious Offenses. Serious offenses include A. Gross misconduct or any inexcusable, shameful, or flagrant unlawful conduct. B. Serious dishonesty, fraud, or deceit, including falsification of documents and making untruthful statements. C. Bribery or corruption. D. Gross negligence in the performance of duty or conduct that is reckless and inexcusable, which results in the client being deprived of his or her day in court. E. Conviction of a crime involving moral turpitude. F. Grossly immoral conduct or an act that is so corrupt or false as to constitute a criminal act or so immoral as to be reprehensible to a high degree. G. Misappropriating a client's funds or properties. H. Gross ignorance of the law or procedure, or the disregard of basic rules and settled jurisprudence when either is attended by bad faith, malice, or corrupt motive. I. Grossly undignified conduct prejudicial to the administration of justice. J. Sexual abuse. K. Gender-based sexual harassment or discrimination. L. Open defiance to any order of the court, tribunal, or other government agency. M. Threat of physical or economic harm amounting to a crime directed at a fellow lawyer, the latter's client or principal, a witness, or any official or employee of a court, tribunal, or other government agency. N. Willful and deliberate forum shopping and forum shopping through gross negligence. O. Intentional violation of the rule on privileged communication. P. Violation of the notarial rules except reportorial requirements when attended by bad faith. Q. Intentional violation of the conflict of interest rules. R. Influence peddling or using one's relationship to obtain a favorable action on or outcome in any pending matter or proceeding, directly or indirectly, with or without monetary consideration from any officer of a court, tribunal, or other government agency. S. Unlawful discrimination under Canon 5. And T. Sale, distribution, possession, and or use of illegal drugs or substances. Section 34. Less serious offenses. Less serious offenses include A. Simple misconduct or such misconduct without the manifest elements of corruption, clear intent to violate the law, or flagrant disregard of established rules. B. Simple negligence in the performance of duty or such negligence which does not result in depriving the client of his or her day in court. C. Violation of Supreme Court rules and issuances in relation to bar matters and administrative disciplinary proceedings, including willful and deliberate disobedience of the orders of the Supreme Court and the IBP. D. Simple dishonesty. E. Other violations of the conflict of interest rules. F. Prohibited borrowing of money from a client. G. Prohibited lending of money. H. Other unlawful threats. I. Instituting frivolous or baseless actions on the basis of a final decision or order dismissing such action for being frivolous or baseless. J. Violation of the sub judice rule. K. Deliberate failure or refusal to pay just debts. L. Termination of legal services absent good cause and written notice. M. Use of intemperate or offensive language before any court, tribunal, or other government agency. N. Unjustifiable failure or refusal to render an accounting of the funds or properties of a client. O. Unauthorized division of fees with a non-lawyer. And P. Other violations of reportorial requirements. Section 35. Light offenses. Light offenses include A. Violation of IBP rules and issuances governing membership in the IBP. B. Use of vulgar or offensive language in personal dealings. C. Fraternizing with the officials or employees of a court, tribunal, or other government agency where the respondent has a pending case or cases to such a degree and frequency as would give the appearance of power or influence over them, or which tends to create an impression of impropriety. D. Filing of frivolous motions for inhibition. E. Failure to promptly call upon client to rectify a fraudulent act. Or F. Other similar or analogous infractions of the CPRA. That's it. Canon 6 Accountability Part 2, Sections 21 to 35 of the Code of Professional Responsibility and Accountability. If you find this video useful, please do like, share, and subscribe to this channel. Thank you very much.